Good afternoon. Welcome to the 5th Public Stakeholder Engagement Meeting of the Special Select Committee of the Senate on the Sexual Offences Amendment No. 3 Bill 2021. This meeting is broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. My name is Clarence Rambarat. I'm the chairman of this Special Select Committee of the Senate, and I now invite the other members of this committee to introduce themselves.
Good afternoon, everyone. Renuka Sagram Singh Suklal, member. Welcome.
Good afternoon, everyone. I am Jayanti Lachvidyal. Thank you for being here and participating in our meeting. I am a member of the committee.
Good afternoon, everyone. Rich is a member of the committee.
Good afternoon, everyone. My name is Raja Gaspard. I'm the Director of Public Prosecution.
Thank you very much, DPP. We also have, apart from the Director of Public Prosecutions, we also have with us the representatives of the Rape Crisis Society of Trinidad and Tobago, Child Welfare League, and the Association of Trinidad and the Trinidad and Tobago Association. Let me get it right. The Association of Psychologists of Trinidad and Tobago. So I would invite the other representatives to introduce themselves, starting with the Rape Crisis Society.
Hi, good afternoon. Kimiko Scott, representing the Rape Crisis Society.
Thank you very much. The Child Welfare League of Trinidad and Tobago.
Well, George representing Child Welfare League with Ms. Scott, Ms. Ross.
Okay, thank you very much. We have Dawn George from the Child Welfare League of Trinidad and Tobago, and we also have Mrs. Cheryl Allen Ross from the Child Welfare League of Trinidad and Tobago. Can I now invite the Association of Psychologists of Trinidad and Tobago?
Alistair Sandy, clinical psychologist and a member of the Trinidad and Tobago Association of Psychologists.
Good afternoon, Dr. Karen Moore, clinical psychologist with children and adolescents, member of the Trinidad and Tobago Association of Psychologists.
Thank you. Okay, so the Association of Psychologists of Trinidad and Tobago is represented by Dr. Karen Moore, Alistair Sandy, and Charles Collier. Thank you very much. So I want to move straight into, we have received written submissions from the 4 stakeholders who are before us today. I want to thank them for their submissions. I want to also say that this committee is supported by the Secretariat provided to us by the Parliament, and also by the officials of the Office of the Attorney General and Ministry of Legal Affairs, led by the Honorable Attorney General himself, and representatives from the Office of the Chief Parliamentary Counsel and the Law Reform, as well as the Criminal Justice Unit. I want to thank them for their support, and we would move straight into a consideration of those written submissions we will receive. And I would now ask Member Lachmi Dial to lead us off in respect of the Rape Crisis Society. Thank you.
Thank you, Chairman. Good afternoon, everyone. So let me start off by saying thank you to the Rape Crisis Society for your comments. And also thank you very much for the work that you all do. I think it is very commendable work. I know NGOs, it's not an easy job to take on, especially with these types of type of work that you all do. It can be emotionally draining and so on. So again, I commend you all and thank you for participating in our little exercise here today. Let me get straight down to some of the questions that I have dealing firstly with voyeuristic disorders. It came up with other stakeholders with respect to two things: stiffer penalties where the offences involve children, as well as a mandatory type of requirement for counselling and some sort of intervention as part of the sentencing process. Now, I know that you all are more focused on the survivors and in assisting survivors, but in the course of doing that, especially because you deal with not just stranger rape, as we call it, but perhaps even persons who are victims of incest and so on, survivors of incest, how do you view those concepts and those ideas? Do you feel that there is merit in making some sort of mandatory counselling? Because have you seen a history of persons escalating from offences like voyeurism towards more serious offences like committing incest, rape, and so on? And do you think counselling would be something, a mandatory form of counselling in this bill is something that would be useful?
Definitely would be useful from our counsellors, and in terms of feedback from our clinicians. We do have some perpetrators who have been willing to identify as such and would like to receive assistance, who have undertaken counselling sessions with us. And in light of improvements that some of those persons have shown in progress in their treatment plan, we would say that yes, persons who are perhaps charged with voyeurism or brought to court will benefit definitely from counselling, and that should be included as a mandatory or part of the process. I don't have numbers currently in terms of statistics of persons getting better, but I think one person they are getting better and not escalating would definitely be beneficial to us all.
Now, when we speak about punishments, we always try to balance punishments and the need for rehabilitation as well, because of course you can't hold people in a cell forever and they're going to be let out back into society at some point in time. With respect to stiffer penalties when the crimes relate to children, I've thought about this a lot. The parent in me wants to say, if someone commits this offense, lock them away and throw away the key and don't ever let them back out. But the more rational thinking person, trying to be objective, thinks that if someone is committing, let's say, an act of voyeurism as it pertains to a child, then that perhaps is a clear indication that we don't that traditional forms of sentencing may not be appropriate in this case. Do you tend to agree with that? Do you think that we need to have a wider discretion in terms of sentencing for persons with respect to children, or would you support the call that has been made by many others for much stiffer sentencing, traditional sentencing, as it relates to children?
Adult perpetrator on child, yes. And that would be, I think, what was included in our comments as well, that there's another element that comes into when it's somebody who's looking at a child rather than an adult. And there should be stiffer penalties for that sort of offense.
Stiffer traditional penalties as in prison time, because, we have the thought that, as I said, the rational side of some of me thinks that sometimes when the way that our prison system works and the reality of it is that perhaps a person in those circumstances going into prison may come out worse than they went in. We have it's known that we have a lot of allegations of sexual offences being committed in the prison, abuse and so on. So, how do we balance that? Do you think that judicial officers should have a wider discretion to perhaps maybe even not send someone in those circumstances to prison, but to rather impose very strict mandatory treatments?
Yes. Treatments, I think, over mandatory or stiffer jail time sentencing.
Okay. The Public Defender's Office, who appeared before us on the last occasion, also felt that more leniency, well, not leniency, but more alternative forms of punishment were required for offenses involving two children, particularly with the taking and sharing of images and videos and all of that. Because of course that level of promiscuity and the sharing of the recordings amongst children, it's not necessarily that they understand fully the extent of what they are doing. Again, do you have a lot of cases of teenagers who are involved in that type of activity and who may suffer as a result of that type of activity coming to you as for counseling and that sort of thing?
Usually when they come to us, there would be a referral from the Children's Authority or a referral through the court system. And in some occasions, the sharing of material may be part of what was exhibited in their behavior, but it's not usually the only reason that they would come to us. By the time children are seen by our counselors, it's usually a lot more serious situation than sharing of images, while that may be a part of what has been noticed in their behavior.
So do you all, just out of curiosity, do you get a lot of referrals of males, young men particularly, who are do you see a history of this type of behavior occurring prior to the event that might have triggered the person coming to you? So basically, have incest survivors said, my uncle used to watch me while I was in the bathroom, and then one day he committed this, and then that's how they get to you, kind of thing. Do you see a lot of that?
Yes, there is an escalation, and in survivors of sexual crimes where the perpetrator is known, usually there would be steps leading up to the actual act, definitely, and voyeurism is one of them.
Okay. With sharing of images, you commented that you didn't think when we speak about the, what we call the revenge, I have an issue with that revenge one, because I think revenge implies that someone caused you harm and you're taking revenge, but it's humiliating and causing distress. You thought were the underlying things and you wanted to include in that revenge. But I understand. Why do you think that it's not wide enough to capture those instances where it's because these things typically occur where a relationship breaks down, right? And that's why we call it revenge. It's the person ending the relationship who's usually on the receiving end of the humiliation. But do you feel that the clause doesn't capture that well enough? That's clause 22B.
I think it was just in conversation among our management committee, the idea of vindictiveness not being captured within the initial write-up. So revenge indicates that the person is purposely distributing material to get back at you. And maybe I could understand right away your retort that says revenge is not necessarily what we want to cover. So yes, I could say that with perhaps our language may be a bit too much or too harsh.
Yeah. The problem with including something like I think if you
it's the intent.
Yeah, it's to prove that your intent is revenge, perhaps, and not just humiliation. I think that it's well known. Establishing that there's a revenge motive makes the offense harder to prosecute, in my view, as opposed to it's easier to prove that what you're doing will cause humiliation or distress. I think that would cover what you would have raised. Is there anything else in particular? I think most of what we've most of what we've discussed before, we've covered it. So do you, there's another, well, I don't know if you would want to speak on this. There was something else that came up with respect to getting something in the form of like an injunction. This is with respect to the sharing of images and all of that. And we thought about, with domestic violence orders where you can get an interim order to stop the thing that's happening. And the thinking behind it is really that it takes quite a while for these matters to move through the court system, and the bill in its current form would enable a judicial officer to make an order to destroy the image and all of that at the end of the matter. What's your view on that? Do you think that it's enforceable? Do you think that, I know that's probably outside of your remit, but do you have a view on it, particularly in terms of minimizing the distress that could be caused to victims of these types of offenses, like the taking and sharing of images with or without consent?
I don't know if we want to comment on that right now. Right away, because it is specifically meant for children, an injunction would most likely be useful because of the harm, especially to the child. And the court matter would take a while, but let's come back to that at another date. Appreciate that you have posed the question to us as well.
Sure. Okay, I could give way to any other member who may have a question now for the Rape Crisis Society. Thank you, Ms. Thanks.
Thank you very much. I want to invite member Sagram Singh Suklal to lead us off on the Child Welfare League and then the Association of Psychologists, and then we would move to the DPP. Sorry.
Thank you, Chairman, for the opportunity. So I would start by looking at the Child Welfare League of Trinidad and Tobago, and as Chairman indicated, then move into the Trinidad and Tobago Association of Psychologists. To the members of the Child Welfare League of Trinidad and Tobago, firstly, on behalf of the committee, I want to certainly thank you for joining in this discussion, and thank you most sincerely for the submissions that you would have given. It is clear from your submissions that, and if I may quote, we stand ready and willing to support good practice that will be in the best interest in the fight against such crimes against our citizens. So it is clear from your submission that you're in support of the amendments that are being proposed in this bill. But please be minded that during the course of this discussion, at any time, if there may be other submissions that you wish to make, you can alert the chairman as the same, and I'm sure you will be given the opportunity to make those submissions, or if there's a question or point of clarity that you may also require during the course of this submission, I'm sure our chairman will be willing to give you the opportunity to seek that clarification. So again, to the Child Welfare League, as I said, it's clear from your submissions that you're in support of this amendment, and we do look forward to you staying in this session. And at any point, as I would have indicated, do feel free to jump in with any questions or concerns you may have. Chair, so that in essence is really the point I want to make to the Child Welfare League. And now, Chair, through you, I would move to the Trinidad and Tobago Association of Psychologists. Again, good afternoon, and thank you so very much to Dr. Moore and her entire team for joining us. As a family law practitioner as well, I know how critical psychologists are, of course, as it relates to assisting the court in determining the implication of more so sexual offenses on the psyche, the mind, and the development of a child. And certainly, I know I can speak respectfully through the chair on behalf of the committee in thanking the Trinidad and Tobago Association of Psychologists for the role that you all play in assisting in the administration of justice, more so at the family court, the children court. That being said, if I may jump into your submissions, there are a few questions that I may have, and I'm sure members, my other colleagues, can feel free to jump in at any time. So we know what psychologists do, but simply for the record, what is the rationale? So there's in your submissions, well, if I may go through your submissions, there were certain points that were made as it relates to the interpretation section of the bill. Of course, you would have highlighted issues as covered, uncovered. Throughout the bill, in essence, there were certain terms that you would have made recommendations. And what I can say is many of the recommendations, some of the recommendations that you would have made would have also been recommendations by previous stakeholders. And what we would have to do when we sit on a clause by clause analysis of this bill is, of course, at that stage, as a committee of the whole, consider those submissions. So I thank you for offering your suggestions on how, with respect to how you believe certain terms in this bill ought to have been, defined, right? Now, what was out of all of the suggestions that was made, one of the areas and one critical submission that you would have made was relative to the definition of private parts. And I recall there were other stakeholders who would have also referred to private parts, but the definition, the submission you would have put forward, what in particular was as it relates to, and if I may quote, the breast of a female person, whether or not the breasts are sexually developed, that was a part. And then you would have also gone on in that particular submission to speak about, and if I may quote, unless there is already local precedent where female persons include male to female, transsexuals or transgender individuals, it may be best to explicitly mention their inclusion. So a question, of course, to my mind came out, you were asking whether or not there is already local precedent that includes transgender persons as it relates to this piece of law, any other law. What I can say is, and of course, looking at and in the inclusion, looking at the inclusion of transgender, it requires more critical thought and analysis. The bill that appears before us in its current incarnation, remember, it's an amendment to the existing Sexual Offences Act, and if that inclusion cannot be made unless, as a committee, we have the opportunity to revisit the act in its entirety. Because this is not a standalone clause. By the inclusion of transsexuals and transgender would require us to look at the bill in its entirety. I hope you're following the submissions that I'm making. And as a consequence of that, so the bill that appears before you is an amendment to the existing law. And for us to be able to carefully consider the inclusion of transgender, what I'm simply suggesting is that it would also require us to step out of the bill itself, the parameters of this bill, and review the entire legislation for us to be able to determine a position as it relates to this inclusion in the law. To answer the question as well, unfortunately...
Member, let me just intervene because I don't want to overload the psychologists. I know their workload is already hard, and they may have to come and examine us professionally. I want to just zero in. So I want to ask the association, we've had submissions on several things from previous stakeholders. We've had a lot of submissions on what you have identified. So I would just ask the association rep to zero in on some of the areas that we would like to get further information on. I note what you've said in relation to private parts. It's something that the association could expand on for us. And I've seen where they've highlighted specific parts of their submission. And I just want to invite them through, with your assistant member, Sagram Singh Suklal, to just go through the submission and highlight anything that is in addition or different from what we've heard from previous stakeholders. So let us start with the association reps taking us through that submission they've made on the definition of private parts.
Guided Chair. So we are free now, Dr. Moore and your entire team. Based on the guidance of the chair, you're free at this point to revert to your submissions made on the private parts and take us through your rationale, because that is, as chairman would have rightly indicated, this is an opportunity for us to solicit from you, your mindset and views as it relates to this definition and the submissions that you would have made relative to the same.
Okay, if I may, thank you for the opportunity. Mr. Sandy, if you will, it may be beneficial for you to address the part about the transsexuals as it pertains to the definition of private parts.
Okay, so in my mind, when making this particular submission, is that the general law, the purpose of that particular law is to account for the humiliation that will be faced if, let's just say, private parts of a particular individual were displayed or copied or used in a way that was beyond their permission. And it is not clear to me that the humiliation that will be visited upon a cisgender individual will be different from the humiliation that would be visited upon somebody who is a transsexual. Therefore, we don't want to have a location in the law where an individual is not covered for the same harm. Right? So that was my intention in terms of we should possibly specify that, in particularly since there would be a difference in how we would usually portray a male and a female. Okay, so say it's a male to female transsexual that has been the victim of a crime. Right? We do not want that. Let's suppose that the torso area is displayed for whatever particular reason, revenge porn or whatever it is, that this particular person, because the same humiliation could visit upon this particular person, but we don't have the coverage in the law for this particular person. Right? So that was my idea in terms of submitting that particular possible change.
Thank you very much, Mr. Sandy. As we're on this point, you also offered an interesting submission where it speaks to for further protection of transgender individuals who may have not transitioned, specify whether or not surgically or or augmented, I believe, right? Yeah, I believe that's what it says. Can you just, for the record, take us through that particular submission?
Basically, it's just meant to make sure that even though an individual, specifically in this particular case, a male to female transsexual, is the victim of a crime where just the torso part is taken a picture of without their consent, that they still have some coverage in the law, whether they've made the transition or not, so whether they have actual a full breast appearance, right? That they still have coverage on the law, because it is still quite possible for humiliation to be visited upon an individual, even if they have not gone through that particular physical process or hormonal enhancement or whatever it may be, that this individual without their consent would still visit emotional harm upon this individual.
Okay, so thank you very much for that. Now, this question is for any member of the committee. Now, there was a suggestion at paragraph 5 of your submissions. There was a suggestion with respect to the incision of clinically therapeutic after medical. That would have been, of course, in your submissions on the proposed clause 22A3 of the bill that appears before you, right? For my benefit, I mean, out of curiosity as well, and I'm sure for those of us who are not, we are not, specialized as you all are, if you can take us through what was the rationale behind the incision of clinically therapeutic.
Okay, so as originally appears carried out by an authorized person for medical, forensic, scientific, or educational purposes. And so what was proposed was to say, carried out by an authorized person for medical, clinically therapeutic, forensic, scientific, or educational purposes. It is simply to provide coverage for the basis under which there is some exposure, or in this instance, the generation of an image, or the taking of an image. It was also noted by another member that there is some debate as to whether or not there is any valid clinically therapeutic basis under which such an image might be taken. So that remained in dispute. The submissions of the association were made by individual members and were not necessarily consensus agreements regarding the various elements of the bill. I don't know if that answers your question.
Thank you very much for that submission. Now, of course, when we looked at even in clause 22A now, right, if I may respectfully take you to that clause of the bill, in your submissions, for the record, what is irrational though, coming out of the fact that there's not a settled position as you would have advanced relative to the circumstances in which a psychologist may be required to look at these images or and so on. What is irrational, and any member of your team is free to answer, for including a psychologist as an authorized person under this bill? From your experience, for example, matters that may appear before members of your committee, why do you believe it's critical to make that inclusion as well under that authorized person provision?
Again, this comes back to the fact that individual submissions were made and there was not consensus about them. And in fact, that there are later remarks that indicate questions as to whether or not there are valid circumstances under which any psychologist would need to view such an image.
Thank you very much for that. Now, if we would continue with the submissions, I'm still at paragraph 5 of that submission, and we have a submission being made by the association, as it was by many other stakeholders, as it relates legal proceedings. And in that particular submission, you all would have visited, it stated that I can see abusive spouses, partners using this clause, claiming it was needed in legal proceedings to prove how depraved their partner was, and it goes on. In this particular submission, again, a question that's posed to any member of your team, can you take us through the major concerns? So yes, I get from here what is one of the major. If you can simply just take us through the association's concerns or any members' concerns as it relates to these legal proceedings and your fear of legal proceedings. Of course, images. If I may look at the bill itself, a copy of the bill that appears. It says that a person does not commit an offense under this section if the acts that are alleged to constitute the offense are, well, of course, for legal proceedings. So maybe if you can take me through any additional submissions you may want to make relative to your concerns on legal proceedings. And as someone, of course, not being liable for that offense if these images are taken for legal proceedings.
Dr. Moore, would you be kind enough to explain further?
Yes. Good afternoon to everyone. Thank you for the opportunity to appear here and to further clarify our submissions. Our concern there, and I believe that may have been one of my comments, it's been some time now and I don't have it in front of me, so I can't say for sure. But our concern was that people would use the legal framework in order to take such images and be punitive with them. And that is something that we've seen, especially in matters involving children. that there is an attempt to shame the other partner, to humiliate the other partner, and if the way to do that is by humiliating or shaming a child with these images, then so be it. So in our clinic, well, certainly in my clinical practice, and I think in that of all of those of us who deal with children, we have come across circumstances where a child may have found inappropriate material on the internet, they may have found it at a friend's home or whatever, and when there's a legal dispute, a custody dispute over the children between the parents, that is used as evidence of one parent's unfitness. If you were not unfit, then the child would not have found this, the child would not have been unsupervised on the internet, the child would not have sent these photos of his or herself, etc., etc., etc. So it's not beyond the bounds of probability that somebody would present these images in a court, humiliate a child to say, this proves that the mother or this proves that the father is so unfit because look at these images that this child was able to send out while in the mother's or father's care. And I have certainly had experience, it hasn't got to court yet, but I've had experience of parents throwing that kind of thing at each other. And if there's a loophole to allow them to present these images, there are parents who will humiliate their children in order to get at the other spouse. And I have certainly had experience of a parent standing up in court and in order to humiliate a child, bringing up issues of sexually inappropriate behavior when it had no relevance in the court.
Okay, thank you very much. Thank you very much, Dr. Moore. And this is a good time for me to ask Member Richards to engage the Director of Public Prosecutions, particularly on this point that has been raised by the Association of Psychologists. Member Richards.
Thank you, Chair. Good afternoon, everyone. Thanks for joining us. I know you're quite busy. Chair, with your leave, can I just direct a question to Dr. Moore and the association just before I go to Senior Counsel Gaspard?
Yes, for sure. That is
Thank you. I just wanted some clarity from the association on 2 points. One, the issue of the rehabilitation or the assessment, the psychological assessment of alleged perpetrators or perpetrators who are before the courts, and the importance of that in the context of the diagnosis of the different degrees of the disorder and how that should play into the court's consideration, one. And two, in the new realm of assessment, what the association's thoughts are on the clause, the statement that specifies sexual gratification and how that can be problematic or not in the realm of a psychological assessment that can be used by the courts. Because that sexual gratification component is quite prevalent in various aspects of the bill.
If I might comment here again, in terms of assessment of perpetrators or alleged perpetrators, to my knowledge, there is not a psychological test that is going to identify an alleged perpetrator. They frequently emerge with a perfectly normal picture on psychological assessments. So trying to find one that will not only identify, but as you were saying, differentiate in terms of seriousness of offense, I'm not sure that that is at all possible.
If I could just intervene, the question, I appreciate your response, was based on the person who may have been already convicted. And in the process of rehabilitation, the court is required or preferred to assign an assessment of the person and how they are progressing through rehabilitation before being released back into society, and what your thoughts are on that aspect of it, to reduce recidivism at some level.
There are assessments that will look at the likelihood of recidivism. I'm not sure that there are assessments that can really look at the progress not a standard assessment that would look at your progress in treatment. Treatment for sexual offenders is notoriously difficult, and it frequently is not effective, especially if the offender is not compelled to do so, to be in treatment by the court. But even where they are, it is a really difficult process. There may in fact be assessments to look at progress. I'm not aware of any. I am aware of assessments that can look at your likelihood, as I said, of recidivism. But that people would have to be carefully trained. The court would have to make sure that the person administering the assessment had been properly and carefully trained and supervised on doing so.
And on the issue of sexual gratification, and several of the stakeholders before have raised that issue as a component of this bill, and what the association's thoughts are on that in the realm of whether or not it's a difficult component to identify that someone is being sexually gratified by an image, or if they're doing it for some other reason, or there's some other motive involved.
If I may.
Absolutely.
So there are several issues that are sort of intersecting here. One of them is that the assumption is that sexual misconduct and sexual acts necessarily involve sexual gratification in a direct sense. And that's not necessarily the case. There are different motivations. There was an earlier discussion about revenge and the language of revenge. The truth is that perhaps the closest analogs to sexual offending are addictions. That what we're looking at is compulsive behavior that is often driven by obsessive thinking and beliefs and emotional experiences that are not necessarily rational, but are also not necessarily intrinsically sexual. So sex can be used for the purpose of sexual gratification, obviously, but it can also be used for the acquisition of power. It can be used for the acquisition of control. It can be used for the purpose of humiliation of another. It can be used as punishment. It can be used as inducement. And so the use of the language of sexual gratification can create a misleading perception of the behavior, the umbrella of behavior that is.
Would a more productive claim then be, and I think one of the other groups identified it as a form of sexual abuse because of the power dynamics you've identified in those various categories there?
It can be, but it's not the only thing that can happen. And that's part of the problem is the complexity of sexual behavior. There are so many different motivations and elements that may be at play. That too is part of why assessment is notoriously difficult. Because there is a need to examine on a case-by-case basis, and there's usually a need to examine over a period of time what is really happening with someone, because there can be an immense amount of complexity involved. If I may, while we're on that for me raises the issue of the question of penalties. Whether the question that was asked earlier is whether or not there should be stiffer penalties for child offences. And should judicial officers have wider jurisdiction in the determination of penalties, which for me raises questions of the risk of overly lenient responses and a failure to hold offenders accountable under certain circumstances. It raises the risk of a failure to distinguish between childhood sexual engagement and predation. There are children who become sexually active at a relatively young age. It's consensual. It is not legal, but it is consensual. You don't have the same power dynamics. And then you have child predators, adolescents in particular, who are predators engaged in intentional efforts to exercise power and control over others using sex and to obtain sexual gratification in some instances. And so simply saying should judicial officers have wider jurisdiction, for me, we're talking about dichotomies and not talking about the whole picture. If we're going to talk about wider jurisdiction for judicial officers, then there needs to be an address of wider training for judicial officers so that they're aware of the complexities and the dynamics that are at play. There's a need to address whether or not judicial officers have a propensity for gender-based discrimination that may not be explicit or even aware to them. So, for example, there's lots of evidence worldwide that sexual offenses tend to be treated differently according to the gender, not only of those perpetrating the offense and those who are the victims of the offense, but also those who are adjudicating. And so it seems to me that there's a lot of complexity that needs to be addressed in that. That means if you're going to talk about changing the punitive components, there's a need to talk also about the training.
I appreciate your intervention because you added a different complexity here on the question of sexual gratification and motives to that. I appreciate it. And before I go to Senior Counsel Gaspar and my colleagues, Senator Leslie, you have an intervention?
Yeah, I just wanted to... Thanks very much. And thanks, Chair. I'll try to be quick. Thanks, Paul. Mr. Collier or Dr. Moore, just quickly, you see, coming off of this concept of including sexual gratification, it's the purpose underlying the offense of voyeurism that they look at, that's looked at in the bill. And one of the things I mean, I understand that there could be wider considerations, but at some point in time, we have to sort of pin down what is the objective of this viewing and criminalizing it, because, and I think we had this discussion with other parties about activity that's not geared towards sexual gratification, but it is a form of observing someone using monitoring and so on, like home monitoring and whatever, that we don't want to be captured as voyeurism. So I don't know if there's some other wording or an expansion of that 22A, the chapeau of it there, apart from sexual gratification, causing humiliation or distress to a person. Can you come up with other specific things to widen that section that would capture the things that you all are talking about, that could go beyond just sexual gratification? Because I think we can't make it too wide, because then we would end up casting a net that captures persons that aren't meant to be captured in this bill.
Is it possible to identify who should not be captured?
Well, we've tried to do that in the exculpatory sections of the bill, dealing with, excluding people who do it for legal proceeding. And I thank Dr. Moore for raising that, because I have a real concern about legal proceedings. We've tried to craft, persons who are doing security monitoring, but your purpose behind whatever you are doing when you view someone, I think we have to have something in the bill that makes it sort of specific. So it has to be that your intention of doing the monitoring, of doing the viewing then, is to do something, or it's motivated in some way by something, whether it's sexual gratification, humiliation, distress, or whatever. Otherwise, you would have a variety of things, coming under and being classified as a form of voyeurism, which may not necessarily what we are intending to target here.
I'm a little lost as to who or what that might be. If someone is viewing another person's body without their consent for reasons that are not applicable to some formal or professional activity, I'm not sure why the motive.
Sorry, you're saying that sexual gratification it's wider than that. So I'm just asking, like, how wide do you think we need to go in terms of that aspect of what you view as some form of sexual deviance that might motivate someone to commit these acts? If
the thing that I'm trying to get across is that sexual gratification is not the only reason. And what I'm suggesting is that there are far fewer reasons, or the category of people who would not be engaged in this activity is smaller. There's a very small, I would imagine, there are only a few circumstances under which someone is intentionally viewing images of someone else without their permission. I can't think of a lot of categories under which that would be appropriate and acceptable.
Mm-hmm. Okay, when you say it's wide, sexual gratification is wider, again.
I did not say that sexual gratification is wider. The thing that I said is that there are wider motivations than sexual gratification.
Like?
I've indicated before the pursuit of power, the effort to humiliate and punish. For some people, it is even a form of emotion regulation and management. It varies widely, which is why the question that I'm asking is, other than direct professional service that is being offered, what other reason would someone have for intentionally viewing pictures of someone's nude body without their permission?
Right. Do you think then that those things are referring to the pursuit of power and all of those things, that they can't be captured here because of the word sexual gratification being there? Do you think that we need to include then, as I'm asking, something like blackmail?
I think that what we're doing is trying to create an exhaustive list of a near inexhaustible set of motivations.
Okay. Well, that could pose challenges for, bringing charges, because as you have identified, that, a wide range of motivations. Okay, well, thank you, though. I think it's something we have to give some serious consideration to.
Thank you very much, Member Lakshmi Dayal. Member Richards.
Thank you, Chairman. If I could go on now, thank you for your patience, DPP Gaspard Senior Counsel. If I could start with your submission, that quote-unquote clause 4 of the bill be amended to explicitly list certain commonly used devices such as cellular phones, video recorders, and cameras. This will make it less complicated, or make less complicated prosecutions, and will strengthen the prospect of convictions. Now, the clause for device specifically says, and I'm quoting from the bill, device means any electronic programmable device used, whether by itself or as part of a computer network, an electronic communications network, or any other device or equipment, or any part thereof, to perform predetermined arithmetic, logical, routing, storage operations, and includes an input device, an output device, a processing device, a computer data storage medium, a program or equipment. If you could expand on that and how it would make it less complicated for prosecutions. And I hope I'm not misquoting the Honorable AG, but I think the list was left non-exhaustive and less specific because of the evolution of technology that the bill may need to capture later on. And if you think that is productive.
Well, thank you very much, Member, for the question. My suggestion is not at cross purposes with the intendment as telegraphed by the Honorable AG. Once you use the word includes, I appreciate it's not an exhaustive list, but the way I look at it is like this. While these supposedly technical terms are fine, in terms of police officers finding ease with which to bring prosecutions and to do investigations, you would find that the police officers tend to work better if the act simplifies the device, or the device is more commonplace. To that extent, it makes for easier prosecution, but more particularly, it makes for easier investigation. But not only that, you would find that it tends to attract the attention of investigators more readily than if the devices are technically described as they are in the definition section of device in the bill.
Okay, thank you. If we could move to your other comment related to clause 22A(1), where you have identified, and I'm quoting, clause 22A(1)(a) of the bill, a large capital A and then common A. The observing offense requires proof that the perpetrator knows or ought to know reasonably that the person does not consent to being observed, while clause 22A(1)(b), the underclothes or obscuring offense requires proof that the perpetrator acts without reasonably believing that the person consents to being observed. You identify an incongruity. Clause 22A1C, the recording offense has no mens rea or mental element requirement at all when it comes to the perpetrator's state of mind and knowledge as to the victim's consent. You identify these clauses as being out of sync. Would you care to elaborate on it a bit for us, please?
Well, remember the Sexual Offences Act of 1986 is the act that I consider to be, say, the parent act. And in the parent act, as it pertains to like offences, like the offences of rape and grievous sexual assault, the mental element required that the prosecution or the state would be required to prove does not accord with the mental element as indicated in the bill. Now, the thing about it is, the law is fairly settled as far as the mental element which is required in the case of rape and grievous sexual assault. So to take it outside of that and to speak about reasonable knowledge, knows or ought to reasonably know and so on, it creates a certain level of complexity. It seems to me as though there is a purported marriage between an objective and a subjective test. And that type of complexity is the kind of complexity that makes for difficult prosecution. So in the Parent Act, the mental element required basically is that the offender knows that the person isn't consenting, very simply, or the offender is reckless as to whether or not the person consents. Knowledge, recklessness. Very simple. When we get into...
Because I'm not legally trained, I apologize. The other attorneys here. The identification of that recklessness, could you just give us some more clarity or give me some more clarity on that, please?
All right. Basically, in this context, a reckless act would be an act where the perpetrator knows that there is a risk that the victim is not consenting, and he proceeds with the act nonetheless.
Understood. There were several groups that raised, and I think my colleague Santos raised the point, and it received quite a bit of attention with other stakeholders about scenarios where the nanny cam scenario, I would phrase it, where persons have the right to protect their homes and surveil their homes, and there were considerations as to whether these persons should be told that there are recording devices in the household or in the premises that are not confined to areas where one would expect privacy, like a bathroom. And what you think about that sort of scenario in the context of what the bill is trying to achieve, where the person who owns the property or the premise may have a recording device undisclosed to the visitor or the nanny or someone else, and which may capture pictures or video of the person in states of undressed or exposed without that mens rea of sexual gratification, which may or may not come after, and what your thoughts are on the law as it presently sits in terms of those sorts of scenarios, and who should be protected in the balancing act of the rights of the owner and the right to privacy in certain circumstances of the person in the premises.
Remember, I'm not too sure I clearly understand exactly what you asked.
Could I, Paul, could I just interject, please? Senior, the scenario that we were considering, for example, I have a babysitter and I leave my child at home alone with the babysitter, and I would like to be able to monitor from my phone, for example, what's happening in my home. I don't allow the babysitter to know that the cameras are there while they are attending to my child in the bedroom, in the kitchen, in the living room. But this person who has access to my home decides that they're inviting a boyfriend over. And this has happened to friends that are of mine, inviting the boyfriend over, and they're engaging in sexual activity and so on, and they are being recorded. That's not my intention of putting the camera there. My intention is supervising that person who is employed by me. But it ends up being that I am observing them, and they don't know that I'm observing them, and they end up engaging in sexual activity in my house, and so on. Can I be charged then under this law as it presently, thing? And I had made the argument, and I put forward that it depends on what you do with those recordings later on. But if the person finds out, like supposedly I confront them that, listen, why did you have this person in my home? This is what I found on my camera. And they then know that they were recorded. Can they report me and I could be charged, for example, with voyeurism, or some offense under this bill? That's the type of scenario that people and it happens in real life and people have put forward and that I try to raise. And how do we balance those rights of someone wanting to secure their home and monitor their home versus the rights of privacy of someone who comes into the home?
Right. Does there lay any such fears, Senator Lakshmi Dayal? If you look at section 22, clause 22A1 of the bill, it begins by reciting that a person commits the offense of voyeurism if, for the purpose of obtaining sexual gratification for himself or another person or causing humiliation or distress to that person, he does certain things. In the case that you would have sketched,
right.
It would not have been for the purpose of sexual gratification, it would not have been for humiliation, it would not have been for the purpose of causing distress, and then you are reinforced by the subsection 3, which says that a person does not commit an offense under this section if the acts that are alleged to constitute the offense are C, carried out for the purpose of security monitoring. So you have a built-in statutory provision which gives you immunity from prosecution in those circumstances as sketched.
Right. But the question that came up from other stakeholders was whether or not persons should know if they're coming into your home that you are being monitored. So there's an or here in subsection C1 after that, monitoring home, or in premises where there are signs displayed. And the question arose whether or not it was the responsibility of the homeowner to inform people when they're coming into the home, which to me defeats the purpose of the security monitoring to an extent. But, whether a person could be charged if they don't notify, and whether we should include that sort of notification as an obligation in the private home. What are your thoughts?
And if I could add to that, Member Lakshmi Dayal, just for the clarity, again, I apologize to my novice and ignorance of the law. In the identification that senior counsel just specified there, where it's specified for security purposes, at that point it was initially set up for security purposes. What if after it's recorded, how do you reconcile it may be used for sexual gratification thereafter if the initial intention was not that, the menswear?
Well, the thing about it, Senator Richards, Member Richards, would be that would come down to a matter of evidence. So there would have to be evidence which takes us outside the ambit of security monitoring, and then it becomes prosecutable.
And added to that, I'm glad you mentioned that, because we just had quite an interesting discourse with members of the Psychological Association on that aspect of sexual gratification and whether or not it should be wider, as Senator Lakshmi Dayal was asking, or whether do you think it's productive as stated in the bill for sexual gratification because of the nuances identified earlier on?
Well, that is a very, very interesting point. It took me back to the Sexual Offences Act of 1986, in particular, Section 16 of the Act, which created the offense of serious indecency. And under subsection 3 of Section 16 of the Sexual Offences Act of 1986, that subsection reads, an act of serious indecency is an act other than sexual intercourse, whether natural or natural, by a person involving the use of the genital organ for the purpose of arousing or gratifying sexual desire. In the courts, we would have experienced some difficulty in proving that offense because of the fact that it is somewhat difficult to prove. It was difficult to prove whether or not the act was for the purpose of arousing or gratifying sexual desire. So you would have found that in several instances where it's iffy, charges would have been brought or would be brought under Section 15 of the Act, which deals with indecent assault, which is much easier to prove as opposed to an offense where you have to prove that the act was done for the purpose of arousing or gratifying sexual desire. So it's a very, very germane question.
All right, and in the context of your comment there, you specified genital organs. Do you think the bill as stated and the list of private parts should be extended? Because there are some of the stakeholders who came before us identified that that list is not adequate? Or do you think the inclusion of genital organs would cover, and the circumstance, the law that you just identified would cover this more comprehensively to deal with those circumstances?
Well, the thing about that point, Member Senator Richard, is that when you look at the Interpretation Act in Trinidad and Tobago, Section 16 of the Act, it says that where the word person is used, it includes, so again, inexhaustively, it includes male and female persons. That's the first point. The second point is, in the definition of private parts under the bill, there is reference to the genitals. To my mind, that would cover male, female, transgender, etc. Because all are persons under the Act, and all I dare say would have genitals.
Chairman, I refer to my colleagues. Thank you, Senior Counsel Pascal.
Thank you.
Chair, can I just ask a few other questions? Mr. Gaspar, I didn't get a firm answer from you as to what were your thoughts about the homeowners being required to inform people that they're being recorded. So that's the first one. First question, if you could just give me your view on it. And the second thing I wanted to find out about, we had a bit of a conversation about this recently in another stakeholder engagement with the sharing of videos and the intention behind the sharing of videos on social media and so on. There's currently a video circulating. I think we've all heard about it. TTPS has issued a warning. And someone who identifies themselves as media, that's the most politically correct way I could phrase it, had an interaction with me and said that they shared that video because they feel it's a good example to other young women how to handle situations where men come on to them in taxis and all of that. And I felt that it was quite disgusting that the video was being shared by someone who hold themselves out as a media person, because the uniform of the child is identifiable, the voice of the child is identifiable, and so therefore to me the child is identifiable. Now, how difficult would it be to prosecute a case like that where someone claims that they are doing something in the public interest, seeing that we've included this public interest exemption in this bill? Because I have a real, and it was stated when the bill was piloted that public interest exemption caters for media. And I have a real problem with, one, what passes off as media in Trinidad now, which is, to me, anybody with a phone and playing background music and doing a live on Facebook. And secondly, that, is that public interest? Is the word public interest far too wide and makes prosecution almost, a real uphill battle going forward if they were to share these types of things via social media, which, as we know, goes viral so quickly and is difficult to bring back?
In the first instance, Senator Lachmidale, it is my respectful submission that you'd be sailing dangerously close to persons' enjoyment of private property if you have to mandate that they must put up certain signs within their home to indicate that the premises are being monitored. In any event, the way the act is worded, you have statutory cover by dint of Section C. The cover obtains where the viewing is carried out for the purposes, or the monitoring is carried out for the purposes of security monitoring, either in the instance where a person is monitoring his home, or in premises where there are signs displayed informing person that the premises or designated portions of the premises are under surveillance. I would be bold enough to suggest that under this particular subsection, that is the subsection which says in premises where there are signs prominently displayed informing person that the premises or designated portions of the premises are under surveillance, this excludes homes.
Right. So,
Okay.
so you would support perhaps expanding that? You say that it would interfere with property rights or come close to. Okay, so
I
that's
do not
fine.
support that at all. And
Well,
evidently the drafters of the bill are deeply appreciative of the sanctity of persons' right to the enjoyment of their property as they see fit.
okay. Right. With respect to the public interest points, could we have your
Right.
view on?
With respect to the public interest point, the public interest has always been somewhat amorphous and nebulous. And anything that is amorphous and nebulous always poses challenges in terms of proof, especially where the prosecution is required to prove its case beyond reasonable doubt. Now, if there is concern about certain categories or classes of persons using this public interest factor so as a fig leaf, so as to hide perhaps more nefarious motives, it can be that with respect to children, the public interest factor does not apply.
Isn't that a solution for one limb of the issue?
I beg your pardon, sir?
Isn't that a solution, if I could, Chairman, for a very important aspect of the issue, but on the wider front, it may, as you say, provide a fig leaf for persons who have malfeasant intention and say, well, I am media, this is public interest, and I could publish pictures of or video of XY because I think it is in the public interest and they're a public personality and the public has a right to know.
I agree that entirely. Hence the reason why I said this term, the public interest, is a bit amorphous and it tends to give problems because there's a huge element of subjectivity, if not convenience, in its applicability.
One more question, Chairman. There were several interventions about whether the bill should include voice as part of the identifiable category. So while we have pictures and videos, there was some suggestion by many that some persons who may be engaged in intimate exchanges in a private context, and those voice recordings should also be subject to the bill. And what are your thoughts on that?
The only problem with that, Senator Richard, is that you find that voice recordings tend to create much more difficulty by way of identification than, say, visual images. So you find that voice identification tends to be much, much harder and less specific. Since my voice might sound like my brother's voice, might sound like my other brother's voice, etc. Whereas with visual identification, unless we are twins, identical twins or so, it's very specific. But if the intention is to go wider, well, I can see the rationale for the inclusion of identification by voice, so as to deal with the particular mischief.
Okay, thank you very much, Member Richards, Member Lachmidial, and the DPP. At this stage, I just want to go back to the submission from the Trinidad and Tobago Association of Psychologists. And in the section which you have labeled additional comments and observations, the first comment you've made relates to the issue of rehabilitative sentencing and having a rehabilitative component in the bill. And I want to tell you that we've had several submissions on the issue of sentencing. There is even one element of it addressed in the DPP's submission, but we've had a lot of stakeholders on this issue of rehabilitative sentencing and in relation also to the fines. So we would include this in the consideration of those submissions. I want to say that we've also had several submissions on the issue of the language, gender neutral and gender inclusive, and we've noted that already. You've made submissions on the issue of voyeurism, and you've proposed an amendment to cover the areas of indecent exposure and obscenity, which you submitted is different from voyeurism. So I want to ask the association to address two particular areas in your written submission, and that is the area of indecent exposure and obscenity. We have the written submission, so I just want you to be very brief in that submission. And you've just heard Member Richards engage the DPP on the issue of voice. You have made a suggestion that sexual conversations via electronic media should be included in the amendments. I want to ask you to also, very briefly, tell us about that suggestion. So, one, the suggestion on indecent exposure and obscenity, and two, the suggestion on sexual conversations via electronic media. Thank you.
So the two different things. The one on the indecency was something that I had some difficulty with myself. Again, this was not a consensus component, but rather an effort to include the considerations of a wide array of independent psychologists. And so I cannot adequately respond to that component of it because I had my own concerns about it. The inclusion of voice, I think that the issue that was raised is a valid one by the DPP. The issue of whether or not we can effectively identify people by voice, it technically is possible as far as I know, but as far as I understand, it's also something that requires significant technological advancement in order to effectively do it. It involves the development of a database of vocal utterances to determine distinctions in much the same way that you would with fingerprints or other kinds of distinctive biometric evaluations and assessments. And so, again, I'm not in a position to offer much by way of how that would be accomplished or how it should be accomplished. I think it was simply raised as a question. Don't know if that answers yours.
Yeah. Well, the submission refers to sexual conversations via electronic media, and I wasn't sure if it was in the context of voice. You could have conversation exchanges by voice
note, for example,
or by text. I wanted to make sure that we understood what you meant by that. So I think you've explained it, and I thank you very much. I want to go back to the Director of Public Prosecutions now, and DPP, you've made several observations on the issue of mens rea. Throughout your submission, you've made submissions on mens rea, in particular in relation to 22A1 and 22BA. You've also addressed the issue of sentencing, and you've also addressed the issue of consent in relation to a child. So I want to give you the opportunity, Director of Public Prosecutions, to now take us through your written submissions. We've raised with you some aspects of it, but I want to give you the opportunity to expand on the written submissions, whether you've talked about it in part already or whether it's an area we've not engaged you on. I want to give you that opportunity to go through the written submission.
Thank you very much, Mr. Chairman. If I might begin on the first page of my submissions, I would say the fifth paragraph on that page, or the last paragraph on the page, which deals with section 22A1, or clause 22A1 of the bill. This is the section that we would have spoken about in terms of the mens rea earlier. And I was saying, and I am saying, that it might make for easier prosecution if the mens rea for these offences were to be simplified and brought into conformity with the mens rea which obtains for similar offences under the Parent Act, namely the offence of grievous sexual assault, which finds itself under section 4A1 of the Sexual Offences Act 1986 as amended, and rape, which is section 4 of the Sexual Offences Act 1986 as amended. And in respect of grievous sexual assault and rape, the mens rea is that the inter alia, that the offender knows that the victim is not consenting, or is reckless as to whether or not the victim is consenting. And I am respectfully submitting that if the mens rea is simplified in this way, you would find that in terms of the prosecution of matters, the prospect of conviction is enhanced. I would also like to take you, Mr. Chairman, members, to the anti-penultimate paragraph of my submission at page 2, beginning with the words, "It is respectfully submitted." And it is respectfully submitted that the parallelism between these proposed amendments and the Parent Act can be further enhanced if these amending clauses were to be supplemented by a provision that a child-in-law cannot give consent under the proposed clauses. In this regard, I would respectfully direct the committee to section 15.2, subsection 2 of the Parent Act, the Sexual Offences Act of 1986 as amended. And that section, subsection reads, "A person under the age of 16 years cannot in law give any consent which would prevent an act, in this case being an assault for the purposes of this section." So that can be tailored so as to meet our needs or the needs of the committee, the legislature, under section 22A. So that a child or a person under the age of 18 years would not be able in law to give any consent to any act which may amount to voyeurism, etc. Similarly, a section or a clause like that would also redound to the benefit of one's intentions, since it would be clearly enacted that children cannot in law consent to being observed or recorded in this unlawful fashion.
Question. Sorry,
Yes.
to just ask a question. What about a case where a person under the age of 18, a child-in-law, shares an image which they themselves are portrayed, as well as someone else? We've heard of cases of children in schools and so on making recordings of sexual activity or nudity of some sort, and they decide to share it, or maybe even if it's sharing with themselves. there are provisions under the Children's Act that prevent things from being reshared. And of course, we are also dealing here with persons resharing. What if someone can raise this defense, so to speak, that the person who put it out there is a child or is the participant themselves? But in this case, the participant is a child. Do you think that we need to be specific to say that even if the image gets out there from or originates with a child, that it could still be an offense, because you still want to be able to charge people who are guilty of republishing the material once it's put out there? I'm sorry if I'm rambling. I'm just trying to formulate it in my mind, but you understand what I'm trying to say?
I do.
Okay, yeah. How can we cater for that? Because in my view, this is what I'm thinking. Children do stupid things, and a child may, or even adults, but children particularly may think that this is some sort of fame and it's something to be proud of, and they do it, or they do it because of peer pressure. But then you have adults who are posting and resharing and republishing, and we want to be able to hold them to account, in probably a more harsh manner than the child who does it initially, putting it out there. So I don't know how the issue of being reckless as to whether the person consents when the person is a child. So I'm coming off of what you said about a child not being able to consent. Even if the child is the original sharer, can we then prosecute the resharers who are adults?
To my mind, we can prosecute the persons who are resharing. Okay. And then one of the things you also have to build in is that, just like in other offenses, remember the prosecution of an offender ought not to take place if the public interest, that particular concept, doesn't suggest that the child should be prosecuted. Bearing in mind the ambit of the legislation and the vulnerable categories upon which spotlight is being brought to bear, one would expect that the child would be playing the role in the situation that you would have outlined of an innocent agent.
Unless, of course, there's more than one underage person in the video and it's one of them that makes the decision to share, in which case, well, we've had some discussion about that and treatment options and sentencing and so on. But
right, and I think we need to be clear as to whether or not, to what extent we want to embark upon the prosecution of children.
Mm-hmm. Do you think that the provisions and the latitude given to the courts, the children's courts, under the suite of children's legislation, do you think it is sufficient to deal with cases where children may be charged for these offences because of the wide range of options they have in terms of treating with offenders under those laws?
Yes, and I do believe that that is one of the singing points for the children court.
Mm-hmm. Okay. So you don't think that we need anything additional in this bill then to cater for it? You think that if, for example, a child has committed an offence in this case, that the management of that offender could be adequately dealt with under the suite of children's legislation?
Well, I'm not saying that it's perfect, not just under the suite of children, not just under the suite of the legislation as it pertains to the children court, but I would think that your question should also be contemplative of the role, say, played by other agencies, including probation department.
Okay. Thanks.
Thank you. DPP, you want to continue through your written submission?
Yes, please. Thank you. Mr. Chairman, I also like to look at page 3 of my submissions. That would be the 4th paragraph from the top, in which I again looked at the offence of indecent assault under the Parent Act. And interestingly, it reads as follows. A person who indecently assaults another is guilty of an offence and is liable on conviction to imprisonment for 5 years for a first offence, emphasis mine, and to imprisonment for 10 years for a subsequent offence. This two-tiered approach to sentencing is an approach that I would also like to commend to this committee.
Thank you.
Now, if we look at clause 22B of the bill, it penalizes, or it appears to be concerned with penalizing the taking and sharing, as well as sharing alone of intimate images. So if you look at section clause 22B 1A, it talks about taking and sharing of an intimate image. 1B talks about taking and sharing in certain limited circumstances or for certain designated purposes. But when you look at it as a whole, it appears to me as though the offense created at the proposed section 22B 1A consumes or contemplates both the offenses outlined at 22B 1B and 22B 1C. So
right.
A covers both B and C, in which case B and C, 22B 1, 22 capital B, subsection 1, common B and C are not necessary in the context of this legislation, in my respectful view, since it is catered for and covered by clause 22 capital B 1A.
Right, thank you. I think we understand that submission. I get the feeling that the drafts people may disagree with it, but we understand the submission that is made on that point.
Okay, thank you. And the rest of it, Mr. Chairman, basically is a repetition of the mens rea point.
Right. So I want to engage you on 2 or 3 areas very quickly, your quick views. And these were made in the debate by colleagues who are not on this committee. So several of the members, in particular Senator Hazel Thompson, IE, but also temporary Senator Marsha Walker and temporary Senator Sean Sobers, raised the issue of training. I just want to get your views on that. From where you sit, Senator Thompson, IE, on an area you just traversed on the issue of children offences, and your thoughts on that, and the issue of penalties. Dr. Dylan Ramey, in particular, raised the issue of more severe penalties in relation to offences committed in respect of children compared to offences committed in respect of adults. So on those areas, training, the issue of offences committed by children on children, and the issue of penalties, in particular, the striking a difference between penalties involving crimes on children versus crimes on adults.
Well, to take your second issue first, Mr. Chairman, I am very much in favor of stricter penalties to be attached to persons who commit offences against children. With respect to your first point, if you would be kind enough to elucidate the point again, since I'm not sure I understand what exactly you're asking.
The point has to do with whether you believe that the TTPS and the DPP's office, they would be equipped to deal with these offences, or whether you believe that there is going to be need for additional training of prosecutors, and how do you feel it? Is it easy to do given their experience and expertise in prosecuting similar offences, or is there going to be a specific need as you see it?
Mr. Chairman, I am never one who would advocate that we have had enough training or we have enough knowledge so that we do not need further training. I think, especially given the prevailing winds and the fact that these offences are new offences in this jurisdiction, training can only redound to the benefit of all the stakeholders who are engaged in the process.
Right. Okay, thank you very much. I just want to go back for a minute to the Association of Psychologists on one point raised by our colleague, Senator Dr. Diyal Singh, in the debate. And then I would give the stakeholders who are before us an opportunity to make their final statements. So to the association, Senator Diyal Singh made the point and I would read it for you. He says, there is need to consider that the crime of voyeurism is on a spectrum of disorders, and it may be a gateway to more serious crimes like rape. Therefore, there is need to set the compensation in a way that it would not embolden a perpetrator to move from voyeurism into another disorder, as literature suggests. Now, use the expression compensation in the context of making a submission that in addition to the fines and terms of imprisonment, there should be compensation to the victims. So I just want you to address that issue of voyeurism being on a spectrum of disorders. It is a gateway disorder that leads to more serious offenses, and the penalties should reflect a need to discourage that sort of behavior.
If I could comment there, thank you for reading out Dr. Diyal Singh's comments. Sexually abusive and exploitative behavior is, as my colleague Mr. Collier has said, really, really complex. It's not always a straightforward connection between voyeurism as a gateway leading on to other things. Voyeurism, I think, should certainly be taken extremely seriously because it is sexually exploitative. It is often part of a range of behaviors. So the person may not necessarily start with voyeurism, move on to other things, and stop being a voyeur. The voyeurism is often included in all the behaviors that they're engaging in. So, touching, indecent assault, rape of the child, plus watching the child or the adult dressing, undressing. So it's part of it. And it is a very serious aspect. And yes, does need to be addressed by the law in such a way that it is seen to be extremely serious, because there's sometimes a tendency to say, well, you didn't get touched, so nothing happened to you. They were just looking. They didn't even take pictures. They were just watching you. And again, in terms of the impact on the people who are subjected to this, it's a serious impact, and it should not be viewed as this is somehow lesser. It's not lesser. It is coming from the same dynamic of, I feel entitled to exercise power over you, to exploit you for my pleasure, whether that is sexual pleasure or not. And that's the same dynamic in all sexual assault and abuse.
Thank you very much. I now want to invite the four stakeholders who are before us to make their closing submissions or statements. I want to invite first the Child Welfare League. You've listened, and you've listened in particular to some of the issues raised in relation to your main focus, which is children. And I want to ask the League whether you have any closing comments to make in relation to the bill and in relation to what you've heard before us today.
No, we have said all we wanted on the bill, that we agree with the bill that is before us. And the submissions that have been made today are very enlightening, very informative. And if things can be put in place to make the perpetrators pay for and get rehabilitation on the deeds that they are committing, that will be very good for our children and our young people. Thank you.
Okay, thank you very much. I want to invite the representative from the Rape Crisis Society.
Just to say thank you for including our input today. The Rape Crisis Society submitted their written comments regarding the bill, and we're glad that they have been considered, and we look forward to seeing this process to actual bill coming to pass. Thank you very much for including us.
Do you have anything more to say on the point I raised from my colleague, Senator Dr. Diyal Singh, on voyeurism as being one of the disorders on the spectrum and a possible gateway to rape offenses?
I think we made a comment regarding that as it being a disorder, that there is a spectrum that it will fall under and can be a gateway. But I think there are lots of things that can be gateways, and finding that measure to put in law may be a tricky endeavor to try to say. So right now, currently, no, we have nothing to comment on.
Right, thank you very much. I want to invite the Association of Psychologists, and I want to just emphasize that we have received and read the written submissions. The areas we've engaged you on today are those that we felt you required the opportunity to expand or clarify, and those that we've not specifically addressed today are those that we believe not only from you, but we've engaged stakeholders, and your written submission was sufficient to allow us to understand the point you're making. So I want to thank you for that and give you the opportunity to make your closing submissions.
I would just like to emphasize that, as stated in the act where I see here, I'm not sure if the DPP would have mentioned or been referring to something different, but there is a B here where they say the death of the female person. So I just want to emphasize that although in terms of persons they are referring to genitals, right? They specify female persons. So I'm not an expert in the law or anything like that, obviously, but I just would like to make sure that persons who may not have been born female are still covered under this particular section, since the section specifically refers to female persons, where it refers to death. I don't know if anyone else would like to add a closing remark.
Right. It is something that had been raised with us before, and it has been noted by the committee.
If I may, thank you so much for the opportunity to respond. I did want to return to something very briefly. A couple of things that were mentioned. One was about revenge porn and concerns about the inclusion of that language. And I just wondered if it might be taken into consideration how malice is accounted for in other criminal offenses, and if there is accordingly a model for addressing malice as a component of sexual offenses of this nature. The second thing that I wanted to raise, which was not included in the comments, is about the issue of studying sexual offenses in Trinidad and Tobago. What I mean by that is that we do not have indigenous scientific research of, certainly not a great deal of it anyway, regarding sexual offenses and sexual misconduct in Trinidad and Tobago, and there is a need for such in order to better inform policy development. I would therefore like to ask if there is a way to consider the provision of appropriate resources for the study of these offenses and their address in Trinidad and Tobago. Thank you.
Okay, thank you very much. And the last stakeholder, the DPP, I invite you to make any closing submissions that you have. And based on what we've just heard from the Association of Psychologists, I want to ask you if you have any comment on the issue of revenge porn.
Mr. Gaspar, you muted.
Sorry about that. First of all, Mr. Chairman, I want to thank the committee for extending this very kind invitation to my office. I want to put on record that this is a signal honor, and we take a special pleasure in attending to hearings of this sort, since I'm of the view that it is better for us to make or be given the opportunity to make an input or contribution at the early stage than having to make contributions in the courts of appeal and in the courts of Trinidad and Tobago. So this is a very, very welcome opportunity for my office, and I thank the committee. I also want to thank the committee for giving me the opportunity to hear and perhaps distill the views emanating from the stakeholders who have been with us today and other members of your committee. And I think that the exchange of ideas between and among stakeholders makes for a particularly rich cross-fertilization upon which we can use to go forward in terms of dealing with the mischief that this bill purports to tackle. Just on a technical issue, Mr. Chairman, I know that Section 116 of the Children's Act requires the consent of the Director of Public Prosecutions before an offense can be charged where the offender is a child. I know that the amending legislation which creates voyeurism and which forms part of Part 8A of the Children's Act, Chapter 4601. For the avoidance of doubt, it might be that this should be made clear that these offenses, where the offender happens to be a child, should also require the consent of the Director of Public Prosecutions before proceedings are instituted, which again would tie back into Section 116 of the Children Act.
Okay, thank you very much, Director of Public Prosecutions.
You're welcome.
I want to thank all the stakeholders who have been before us today. I want to thank the media, the representatives from the Office of the Attorney General and Legal Affairs, including the officers from the Law Reform, the CPC, and the Criminal Justice Unit. I want to thank the parliamentary staff, including the IT staff, to ensure that we have the broadcast and we can operate in this virtual environment. And I want to thank the viewing and listening audience who have followed live and those who would follow on the rebroadcast. This is a very important session and an important committee that is at work, and we want to thank you for your support. This meeting is now adjourned. Thank you.
Thank you.
Thank you, everyone.
Recording stopped.